It is my great pleasure to introduce you to our General Counsel, Andrea Goperlud, who is going to walk you through all the great new laws that we have on the books as of October 1st. So.
Thank you. Mia, are you able to say got it on the, I have to do it? Okay, thank you. Thanks. Hi all. I also have a pretty big voice, but I'll use the microphone as well for those online. As Director Khaing said, my name is Andrea Goperlud. I am the General Counsel here at OHR, and I started just back in April. So welcome. Thank you all again for coming on this pretty cold and rainy day. So what I want to spend about 20 minutes on is that as of October 1st, 2022, it was a new fiscal year. And what that meant for us at OHR is that we have new laws that are now into effect. So as Hnin said, that there was 15 extra local laws that we enforce. There is actually now 19. So you'll see the second one, the Human Rights Enhancement Act, is just an addendum to the Human Rights Act. These other 4 that you see on your screen, these are new laws that OHR is enforcing starting, and I'll put an asterisk here, starting on October 1st. So what are these? The Eviction Record Sealing Authority and Fairness in Renting Amendment Act, the Human Rights Enhancement Act, the Sexual Harassment Data Collection and Reporting Act, the Medical Necessity Restroom Access Act, and the Cannabis Employment Protection Amendment Act. You'll see that there is asterisks on the bottom too, and that is because these laws are in effect, but they're not funded yet. And what that means is that until they get funded, OHR is not enforcing them. Once they get funded by the DC budget process, we will begin outreach and we'll become enforcing them. So I'm not going to spend time talking about those 2, but if you do have any questions about what the MNRAA is or the Cannabis Employment Protection Amendment Act are, come find me. I'm happy to talk to you about what those laws entail and what will happen once they get funding for them. You can get to the next slide. So I'm going to spend time, though, on 2 of them. The first is the Human Rights Enhancement Act. And the Human Rights Enhancement Act had 3 main highlights. The first is that it added homeless status as a protected trait. It included independent contractors within the definition of employee, and it expanded the employee protections against harassment. Next slide. So first, yay, we have another protected trait, and that's homeless status. And this is across all 4 of our enforcement areas. So employment, housing, education, public accommodation. For those of you in the housing areas, you may say, okay, well, there was this one, there's a protected trait of place of residence or business, but that only applied to the actual geographic place of your business or residence. It didn't actually specifically include homeless status. So what did the Enhancement Act do? The Enhancement Act made it explicitly clear that homeless status now across all 4 protected traits, all 4 enforcement areas is a protected trait. The definition of homeless status included in the act refers to another act. It says that it has the same definition of Section 2, subsection 18 in the Homeless Service Reform Act of 2005. If you go to that definition, it is very, very long and complicated, and it has a lot of nuances to it. But in essence, what it means is homeless status is an individual, family, or unaccompanied youth who lacks, lost, or who will imminently lose a fixed, regular, and adequate nighttime resident. And this can also include being the result of escaping an unsafe environment. Next slide. Second, the Enhancement Act now specifically includes independent contractors in the definition of employee. Now, for some of you who have practiced before OHR before, we have always interpreted the HRA definition of employee to include independent contractors, but the Enhancement Act now just makes OHR's interpretation clear, and it now is in the statute. What's interesting also is they have defined independent contractor, but they have defined about what it is not. In the act now, independent contractor is defined as someone who is not someone who provides a discrete service to an individual customer. Next slide. Campaign interns, unpaid interns. So would unpaid interns be independent contractors? So interns will be, whether they're paid or not. I think, I don't think your status, as a volunteer, you would be covered. So an unpaid intern should have the same protections. There you go. Specifically in the HRA. So yes, they are covered. Independent contractors are not interns. Independent contractors, there's about an 8 to 10 factor test to determine if someone is an independent contractor, but it's not somebody who is an intern. It's a separate class of individuals who are independent contractors. Okay, gotcha. So the Enforcement Act, the Enhancement Act also expanded employee protections against harassment, and they did that in 3 ways. First, they now include a specific prohibition on workplace harassment. There's now a definition of harassment and sexual harassment, and there's a creation of a broader legal standard. And I'm happy to report that one of the documents that you all should have is a new guidance that we all issued. It is Enforcement Guidance 2302. Which is posted on the website, but you also should have it if you're in the room, which gives you further information about this the new legal standard and the expanded definition of harassment. Next slide. So surprisingly, go back one. So surprisingly, before the Enhancement Act, the HRA actually didn't have a definition of harassment. So the Enhancement Act remedied this, and now there is a definition in our statute. Nope, go one more. There you go. And harassment is defined as conduct, whether direct or indirect, verbal or nonverbal, that unreasonably alters an individual's terms, conditions, or privileges of employment, or has the purpose or effect of creating an intimidating, hostile, or offensive environment. And harassment under this definition is considered unlawful discrimination in the workplace if the alleged conduct is based either wholly or in part on any of the 18 protected traits that are related to employment. Next slide. Most significantly, the Enhancement Act, what it did is it expanded the legal standard for what constitutes illegal harassment. So prior to October 1st, the legal standard of what were considered harassment was under what has been known as the severe or pervasive standard that many of you may be familiar with. And what it required was that the complainant is a member of a protected class. They were subjected to unwelcome hostilities that were based on one of their membership in that protected class. And then that the harassment is severe or pervasive enough to alter the terms, conditions, or privileges of employment. And for some of you who have practiced employment law, you may have recognized that this has created a very high bar for what constitutes and what can qualify as severe or pervasive employment to constitute illegal harassment. In cases highlighted by the DC Council when they passed the Enhancement Act under this judicially created standard, they found one forcible kiss. No way is it going to meet the standard. You know, they found a case where it was one forcible kiss, maybe one kind of grabbing and touching and staring. Nope, not going to be enough to meet this severe pervasive standard. And in one case that the DC Circuit found especially egregious was that, and I will read this all, is that it was a supervisor who had, among other things, grabbed and repeatedly touched his subordinate's buttocks, repeatedly attempted to hug and kiss her, invited her on a weekend trip, cited her attractiveness as a reason for spending extra time around her at work, consistently stared at her, and held his hand on her thigh in the middle of a performance evaluation. And guess what? It didn't meet the severe or pervasive standard. And the council said, no, this is not what the HRA was designed to protect. It wasn't intended to protect these bad actors. So it set forth a new definition of a hostile work environment that attempts to provide additional guidance as to what information tribunals, including OHR, should consider when determining whether conduct constitutes unlawful harassment. Next slide.
Andrea, we have a question in the chat. What are the available remedies for individuals covered under the homeless provision of the act?
So if the same ones, they're entitled to the same provisions under the HRA. So if you were discriminated against on the basis of a protected trait of homeless status, you're entitled to the same remedies that you would be entitled to if there was a finding that you were discriminated against on the basis of, say, race, color, national origin, any of those. So there, it is now a protected trait that is given the exact same weight as all of the other protected traits, the 23 that we have in our that are covered under the HRA. If you can go back one, Mia. So the Enhancement Act now, what it did is it abandoned that severe or pervasive, that really high standard, and instead now explicitly states that there's no specific number of conduct that would be considered unlawful harassment. No longer are we counting up the number of forcible kisses or the number of grabs. And rather, the definition now is directly telling fact finders, including OHR, is that you need to look at the totality of circumstances. And helpfully, actually, the Enhancement Act provides a list of factors that fact finders must actually look at. And that's the frequency of the conduct, the duration, how long it was going on, where it was happening, whether it also included threats or racial epithets or stereotypes or some degrading conduct. And also whether the party not just held at a formal position of authority, your supervisor, but also maybe if there was an informal power relative to another party. Next slide. It also made very clear that there was all these circumstances that courts were saying, yep, if you have this that happened, it's you won't get severe or pervasive. So if it happened, it was a single incident, you're not gonna get there. Or it happened outside of the workplace. No, it's not gonna meet the standard. And the DC Circuit said, no, DC Counsel said, no, we're getting rid of that as well. And so now specifically it says that none of these factors are determinative and fatal of your claim. So even if it was a conduct that was a single incident, that isn't fatal, nor is conduct that was directed at someone else other than the complainant, or that the complainant may have participated a little bit in the conduct, or that the conduct didn't create physical or psychological injury. There was all these cases that say, oh, if the person didn't say it, give them psychological harm, then it couldn't have been severe or pervasive. And DC Circuit is saying, no, DC Counsel is saying, no, that's not determinative anymore. It's not determinative that the conduct occurred outside of the workplace or that it was not overtly directed towards a protected trait. One side note that I must mention here is that this expanded definition, this expanded legal standard of what constitutes a hostile work environment is only applicable for those actions that occurred on or after October 1st, 2022. So if there was conduct that occurred that happened before October 1st, 2022, they're going to be under that severe or pervasive standard, not this new definition. Before I move on to the next law that I'm going to spend just a few more minutes on, does anybody have any questions about the HRA Enhancement Act? That it is just workplace. Not this definition, no. So that's an interesting question. The question is does this apply outside of the employment context to, let's say, neighbors harassing neighbors or in the educational field? So the Act specifically just talks about employment. Now, in those other situations where there's harassment, they look though to Title VII or the Human Rights Act's definition of what constitutes harassment. Sorry. Yeah, or the Human Rights Act. So for instance, neighbors harassing neighbors. There's not anything in the FHA that says this is what we call it a hostile living environment. This is what the standard is. Instead, what you would do is you look to what does harassment mean in Title VII or under the HRA. So although this act, the definition in the Enhancement Act, and it does specifically say it only applies to employment, looking at harassment in those other contexts, I would imagine we will have to look at what this new definition, because that's what we're directed to look at when we analyze harassment in other contexts. Any other questions? All right, next slide, ma'am. So the second law I'm just going to spend a few minutes on is called the Eviction Record Sealing Authority and Fairness and Renting Amendment Act of 2022. It's a mouthful. We have shortened it, and this is not more helpful, in our written materials as ERSFRA, but that does not either ring off the tongue. So at least for the purposes of for the next 5 minutes, I'm just going to call it the act, and we're all going to pretend that you all know I am calling it. This is what what I'm talking about right now. So there's lots of the parts of this act that actually became effective back in May. But the parts that affect OHR did not come into effect until October 1st. And there's 3 relevant parts of this law to OHR. First, it adds a sealed eviction record as another protected trait. It describes types of action that may be considered unlawful source of income discrimination. And then it finally provides an OHR complaint process if there's a violation of the act related to prospective tenant screening. I'm not going to spend too much time on that last portion, except just to say that the act outlines several things that housing providers both can do and cannot do when it comes to tenant screening. And one of those ones that's really important is that housing providers cannot screen out prospective housing renters because they don't have a credit score or because they have a low credit score. Now, if a housing provider, though, does not meet these requirements, in other words, they did screen out someone because of their credit score, well, there's now under this act a way that that person can come to OHR and file a complaint. And if there is a probable cause finding that the housing provider took one of these prohibited actions, then that would be certified to the commission for that evidentiary hearings that Hnin was talking about. In that section, though, what your remedy is various fines. It's a fine structure. There's 2 things to note, though, about that complaint process. First is that as Hnin was closing and saying, oh, you could remove your case to court after starting the OHR process. Under this part of this act, you don't have that option. You have to pick one lane or the other. So if you filed with OHR a complaint, you have to go through our entire process. If you file a complaint with in court, you have to go through their process. There's no avenues off ramps to go and use another forum. The second is that for violations that are occurring within the first 6 months of this act, so from between October 1st, 2022 through April 2023, if there is a violation of a section of the act, the commission can only issue warnings and telling you have to correct it. They can't start issuing monetary penalties until after the first 6 months have expired. Next slide. So the 2 parts, though, I am going to just spend 1 minute on is the first is that we have now another protected trait. This comes to 23 protected traits under the HRA. And that is a sealed eviction record. That is only for housing. So when we were talking about homeless status, and I said it applied to all 4 of our enforcement areas, sealed eviction record as a protected trait only applies in our housing enforcement area. The sealed eviction record in the act is defined as an eviction record that has been sealed pursuant to Section 509 of the Rental Housing Act of 1985. And essentially what the RHA does is it allows for certain eviction proceedings to either be sealed automatically by the courts or upon motion by a party that there was good cause to seal that eviction. Next slide. Second, the act enhanced protections under the HRA for prospective tenants seeking to rent with an income-based housing voucher by explicitly making clear some types of activity that could be considered an unlawful discriminatory practice. So now under this new act, it specifically says that you could not base a housing determination on prior renter history of non-payment or late payment of rent. If that non-payment or late payment of rent occurred when the individual was not using an income-based housing subsidy, and the housing provider could have reasonably known the date that the person received the subsidy. Second, they can't take a housing action based on income level, credit score, or lack of a credit score, unless they are required to do so under some separate law, local or federal law. And then finally, they also can't take into account any prior credit issues that occurred during a time when the prospective tenant was not using a income-based housing subsidy. And again, it's the reasonableness, and the housing provider had a reasonable basis to know when that person received the subsidy. The act also created a rebuttable presumption of discrimination if a housing provider charges more rent for somebody who's using a housing-based, income-based housing voucher, or if they say charge, a fee or a deposit to those individuals using the voucher that they don't charge to people who are not using that voucher. Now, we've heard from some in the community that you have certainly been asking for updated guidance that you can provide your clients. And I'm very, very happy to say that as of December 9th, we have done that. And now on our website, and also that is one of the handouts, we have our enforcement guidance 2303, which talks about these enhanced protections under the act, as well as what can be considered source of income discrimination. That is all I have. Any questions?
Andrea, there's one in the chat. Who does a covered homeless victim file their complaint against?
The entity, so across all 4 of our enforcement areas. So in terms of who they believed took action because of their homeless status. So if they think that it was a business who didn't allow them to use their facilities, that would be our public accommodations. If they thought it was their employer or a prospective employer that asked for an address and they did not have a fixed address and then they didn't get the job, then they would file against whatever that employer is. So you're going, because that one is across all 4 of our enforcement areas, it's the person that they believe took homeless status into effect, into account when making the alleged discriminatory action. Few questions in the room?
What can you do to determine if the right tenant that can pay? You can't look up their employment, but it's sources. What sources can you have to make sure they're the right tenants that can pay?
This is probably going to be something that is a little bit outside my bailiwick about what they specifically can. I am much more about what they cannot. Can you look in terms of when we look at their credit history, you can take into account the credit history, but I'm going to, I will, let me look into it and I can get back to you.
Can I just add there that, for example, with the credit history, it's saying, right, why would you need to get someone's credit history for instance, source of income discrimination if payment is being made by government subsidy payment? So that asking for credit history in that kind of instance could be discrimination. So it's sort of a little bit more narrow circumstances.
Thanks, Sin.
Some of these provisions are only have gone into effect October 1st and will only be issued warnings for the first 6 months. And I just wanted to clarify that the source of income protection specifically has been in effect since May, correct? And our rules
Yes.
different?
What is considered a discriminatory practice, yes, has been in effect since these what we would consider, but it's not that part of our enforcement of it though didn't start until October 1st.
But you have more power than just issuing warnings for the source of income provision.
Yes, sorry. So that the source of income is very separate from the complaints that are talking about prospective tenant screening. Prospective tenant screening is a very narrow about what they can and cannot do, which is totally different from basing it on income-based housing subsidies, which that is just a fine structure. But if you discriminate against someone for source of income actions that are listed here, no, that would not be the fine structure. You'd go through our normal, investigation, and if there was a violation, you'd be allowed the remedies that you would for other housing violations. Any other questions? Any other questions in the chat, ma'am?
No more in the chat.
Okay. I'll be around if you want to come up, ask any questions. I also have a whole table worth of lawyers that are here with me too. And I'm sure that they would love to chat with you all as well. But if we want to move on to our next portion of the programming.
So I think next, Maya, our interim manager for community and outreach, is going to come and introduce all the different units at OHR. so that you know who's who and what they do now that you have a better understanding of the process. And I know I'm not sitting next to the mic, but just real quick, just to put a bow on Andrea's presentation, just based on your questions. Just remember, these are, like she said, enhancement, right? Source of income discrimination already exists, right? Sexual harassment already is prevented and prohibited under the Human Rights Act, but now they've amended the laws in such a way that it's a broader reading or more explicit establishment of what is considered source of income discrimination. So just want to tie that